Good afternoon.
Christine, good afternoon today, and it's good to have you here, and thank you for joining us. So today is the first day of December 2020, and we are at the virtual African International Mediation Week and second strategy conference. This is our 2 p.m. event today, which is part of the practitioner seminar series, where we have mediation practitioners who are giving us insights based on areas of expertise, areas of interest. And Christine Kipsang, who is our presenter for this session, is the one who will be taking us through. Christine Kipsang is court annexed mediator, and she is a court annexed mediator, and she's also the vice chairperson of the Mombasa branch of the Law Society of Kenya. And based on that, then her session is categorized under Mediating Council Practitioner Series. Mediator Christine, thank you for joining us. We will have the national anthem. I will give the first stanza of the national anthem, and then we can be able to invite Mediator Christine Kipsang to take us through the next part of the session. So, Mungu nguvu yetu, ilete baraka kwetu. Haki iwe ngao na mlinzi, na tukae na undugu, amani na uhuru, raha tupate na ustawi. So once again, ladies and gentlemen, this is our practitioner seminar series, which is part of the African International Mediation Week, where we take the opportunity to learn from Africa and also to share from Africa, as you also learn and share from other regions that are out of Africa. So Mediator Christine, how are you today afternoon?
I'm well, thank you, Wangari.
You're welcome. You may kindly proceed with your presentation and session, and thank you for joining us today.
Thank you. Okay, let me just get my presentation through the sharing of the screen. Please confirm you can see the screen.
Yes, thank you very much. Yes, we can see the screen. Thank you.
Thank you. So I'll take about 10 minutes, then I will invite questions. And this topic, why I chose for this seminar or this mediation week, is to encourage each one of us to understand the court annexed mediation, its applicability, and how we can actually encourage people to take it. So mediation, as we all know, is an alternative dispute resolution process where parties resolve disputes with assistance of a third party called a mediator. And most of us who are logged in today, they are mediators, so I do not need to go into the nitty-gritties of mediation because we know the benefits of mediation or benefits of becoming a mediator. So I will dwell so much on the court annexed mediation, and I would say this is a process that is part and parcel of the judiciary as we know it in Kenya, and it is under the umbrella of the court system. So if you look at the hierarchy of courts that systems that we have in Kenya, you find that right at the bottom, we have the tribunals. And then we have the Qadhi's court that are established for Sharia law. Then we have the Children's Court, which were established under the Children's Act of 2001. Then we have various subordinate courts, what we call the Resident Magistrate Court, the Senior Resident Magistrate Court, the Principal Magistrate Court, the Senior Principal Magistrate Court, the Chief Magistrate, and then we have special courts, that is the Environment and Land Court, and the Employment and Labor Relations Court. Then we have High Court, Court of Appeal, and the Supreme Court. So all in all, you find that there is already a system that is established through the Constitution and the various laws that we have in Kenya for the court system. Then Why the reason court annexed mediation was started as a project is because of the backlog of cases that we have in Kenya. And as we all know, there are various parties who go to court daily to seek various reliefs. Reliefs is like solutions or settlement to their disputes. And you can have maybe a case of where you have loaned somebody and they have failed to pay you. So you're going to look for a debt relief. You are also maybe going there to find that how you can get your money back because maybe somebody has refused to pay or he has paid less the amount you agreed or he has paid without the interest. Then there is issue of seeking relief for compensation. Many a times you may find for example, you have a road accident case and then you get injured, you go to hospital, you seek medication, you pay the money that you did not expect to pay. And so in all this, you find that there's an insurance that covers the motor vehicles that was very new. So you go to court to seek compensation. There's also the issue of damages. If somebody like destroys your land or destroys a valuable item, you can go to court for damages. Damages is essentially payment of money. There's also the issue of restitution. Many a times you find land cases, it's about restitution rights, where you find somebody sells you land and then they sell to another person, or they sell land and then later on they want to claim it. So there are many rights that people injure others and people go for them. In the family front, we have divorce matters. Somebody can be seeking to end a marriage or can look for a separation or can also look for application of conjugal rights. And then when it comes to children matters, you may be looking to adopt a child, custody, and even maintenance matters. And in all this, there's an issue of litigation costs. So when you go to court, there are many options that you have in terms of what relief you want in a particular case. And what I am arguing in this paper is that once litigation starts, depending on the case, the losing party can file an appeal, like the way I said, right from the county, they can go now to the High Court, from the High Court to the Court of Appeal, from the Court of Appeal, they can go to the Supreme Court. So there's no way of stopping a party who wants to pursue a matter in court. So you find that once a matter is filed, there are many chances that this matter may be, one party may appeal and you may be in court for a very long time. And the other point I want to put across is that the number of cases filed each year is increasing in our courts. And also the number of litigants. You may find even a litigant as more than 5 cases. He may have a case of land, may have a child custody case, may have a matrimonial case, may have a divorce case, and he may even have a case where maybe somebody has forged documents. So you may have a criminal case of forgery of documents. So all in all, you may find one person having several cases in court. And you keep seeing this person going to court, and I'll ask yourself, where is the person in court? So in all, we are saying that litigation takes a long time because the formal process requires stringent procedural formalities. And disputes take a considerable number of days, months, or even years to get concluded. Why? Litigation requires the procedural, what we call procedural fairness, where you require the person to be informed of the dispute, and then they're given a certain point in time to respond. Like in Kenya, you are given 15 days to get to read your papers, look for representation, and file your matters in court. So all in all, litigation, when it starts, it takes a long time. Then you find come the time we started the Constitution of Kenya in 2010, we embraced the issue of alternative dispute resolution mechanisms, and mediation is one of them. So the court was not to be left behind, because it realized if they started court annexed mediation system within the court system, then they will be able to resolve many matters that are pending in court. Like I've said, the backlog of cases that are in court is quite high. So in court annexed mediation system, I want to say that this is the best system because we are seeing the softer side of the court, the softer side of the court system. Because you know in Kenya, we have the adversarial system of resolving dispute, where you have a plaintiff and a defendant coming to argue their case in court, and the court has to determine. The court does not interfere with how a litigant prepares a case, how he presents the case. It is only at the decision level that the court will come in and now determine who is the winner, who is the loser. So in court annexed mediation, we are privileged. It's a privilege. I want to say that maybe we have not understood the magnitude, how beautiful this court annexed mediation is, because it's a way of the court saying, come, because I've already put the systems for you, and we have been encouraged to resolve the dispute. So in court annexed mediation, we have the mediators team, which is the mediation accreditation committee, and is headed by a court of appeal judge. That tells you something. It is not headed by a magistrate, it's not headed by a Kathy, it's not headed by a high court judge, it is headed by a court of appeal judge. This means that the judiciary is appreciating this system to be of high rank, of high importance, and of great support for the court system. So being headed by the court of appeal judge, it shows that it is taken seriously. So it is time for us to take this court annexed mediation seriously and to appreciate the system because of the structures that have been put in. Then we have deputy registrars. I'm sure most of us have met Caroline Kendagol, Honorable Moses Wenjala. They are beautiful, beautiful human beings. They actually are trained in mediation. They appreciate mediation. They appreciate parties who want to resolve the matters through mediation. They appreciate mediators. They also look at the issue of the files that are to be screened. And as of July 2017, 1,550 cases were screened, and a quarter of these matters reached settlement. And remember, this court annexed mediation was started in 2016. And you see, by even like 1 year later, matters have been resolved that have been in court for various years and resolved. So we have deputy registrars. And so the fact that these deputy registrars are in the level of magistrates. So it means that they have already resolved matters through the court system. They have seen that litigation is not working, or it takes so long to work. And that's why they are passionate and given to actually support the court annexed mediation. Then we have the mediation secretariat that is equipped with tools and manpower. You will agree with me, when a matter is screened and the parties are informed, they keep on checking with the mediator. How far have you gone? Give us what can we help you with? Because they have the phone numbers, they have the resources, they have the manpower, and they are able to actually put people there in the secretariat who are passionate about mediation. So all in all, you find that it is very essential that we take the mediation secretariat as our partner, a partner who is ready to see success and to ensure a success takes place in the court annexed mediation. So many a times you find if it's a litigation issue, you find the courts are just letting the parties take their procedural challenges or technicalities, and you may find one application or another, and maybe you'll be losing in the processes. But in a mediation secretariat, they are geared towards encouraging you to resolve your dispute. Then we have the mediators. The court annexed mediation system, you cannot get into that register because there's a register for mediators. You cannot get into that register unless you prove you're trained unless you are interviewed by the MAC, that is Mediation Accreditation Committee, and you qualify, unless you sit with a qualified mediator and you continue showing that you have gained the knowledge and you have interest in mediation work. So this register is maintained by the judiciary. It is in the website, judiciary website. That is the top website we have in the judiciary. So what does that tell you? It tells you that mediators in Kenya through the court annexed mediation are being taken seriously. And you can, as we all know, once you qualify as a mediator and you can resolve matters through mediation, it is you to actually move faster and resolve matters, because once you remain in the register, it's just not remaining in the register, but for you to undertake matters in mediation. Then we have advocates. This system, the court annexed mediation, is involving a lot of advocates, and we all know that advocates are licensed by the Law Society of Kenya. You cannot be an advocate and you do not have a practicing certificate. So you have a qualified professional with the knowledge and supporting the parties that they represent. Then we have the parties who are already having claims against one another in court. So as a mediator or as part of the system, these parties will be, again, curious to come to the mediation table and find how they can resolve their matter, because it has taken long in the litigation cycle or system, so to speak. Then you find in court annexed mediation, it actually acknowledges that there are parties who are supporting the opposing parties. And really, you do not have to come with an advocate to come to the mediation table. So these parties are welcome. In court, unless you have filed a witness statement, you cannot support a party. Because you'll be like what we call busybodies. You'll be a busybody. You have no clue why you are there. So it's you'll be doing what we call doing a frolics of your own. You will not be having the interest. You will not be having a claim that you can say, I'm interested in this matter or the outcome of it. But in court annexed mediation, we have third parties who come and support the opposing parties, and in essence, with that support, you find a dispute is resolved. Then in court annexed mediation system, we already have the claims already filed in court or about to be filed in court. So that tells you, you do not need to go look for a claim out there. The claims are already there. The issues have already been prepared by advocates who are qualified, and the issues that can easily be checked within the court system. Yeah. So then let me go to the next point. Then we also have the benefits. I want to continue with this issue of the benefits of court annexed mediation. You find that already the trial court have been sensitized about the court annexed mediation. So you have the support of the trial court. Imagine with me for a minute, a magistrate supporting you in the mediation process. That is amazing. That is huge. That is great, because the court wants the outcome as soon as possible. Remember, the courts have this we call performance contracts. So once a matter is screened, the court clerk and the mediation secretariat, they supervise the issue of the screening and assigning you that file for the mediators to take place. The parties are informed by the accredited court annexed mediator. The court provides mediation rooms or premises. Right now, I've just been called by the court clerk in Nakuru, because I'm a court annexed mediator in Nakuru. I'm being told that this internet and there are online protocols that have been shared, so I can actually hold my court annexed mediation cases online. So what does that tell you? There's internet that is being provided, and there's online protocols, so that there's no issue of breaking of the confidentiality. There are mediation forms that are being given. The manual is there. We also have the frequently asked questions. So you find that this process, it is already well equipped. Then we have advocates who are representing parties. Many a times you may find a mediator has to look for the party and actually bring them to the table. But you see now, most matters that are in the court annexed mediation, you find their parties are represented. Very few have no advocates. And you find the advocates help the parties to narrow down the issues through the case summary forms, and even encourage the parties to commit to the process to resolve this dispute. The amazing thing is that the court annexed mediation in Kenya actually requires you to participate. Within 60 days, you are likely to come out with a mediation agreement. Then we have the mediation judge. Many a times people say, when my matter is screened and sent to a mediator, do I have the chance of getting the interim reliefs? Maybe I should stop somebody from constructing on my land, or I should stop somebody from evicting me forcefully. Then the good news with this court annexed mediation is that we have a mediation judge who is available. If you make an application, you get an interim relief. Relief, we said, is a short-term, solution that you get for whatever you are asking for. It depends with the case. So the fact that a matter has been sent for court annexed mediation to a mediator who is accredited by the court does not stay the processes that you need to protect yourself or to protect your property. Then you find that we have the other advantage we have is the court annexed practice directions and the enforcement support. For non-compliance, you may see that the registrar, the deputy registrar, can be informed there's non-compliance in this matter by this party in a court annexed mediation. So it has some force, it has some enforcement support that you get from the registrars, because they can order a party to attend mediation session. If the party is not willing, there's the stringent enforcement support you get of striking out the pleading. Striking out the pleading is like, whatever they had filed as the defense, whatever they had filed as the plaintiff, it can be struck out by the registrar, but that is in the extreme cases. And then there's the payment, of course, when somebody is not complying with the issue of coming for these mediation sessions. So the court annexed mediation system actually allows the registrars to intervene so that the process can continue moving on and on and on, so that we can find a solution. Then in the court annexed mediation, from the manual, right from the other documents that have been provided by the Secretariat, the mediation roles, right, for the mediator, for the client, and any third party who comes, it's quite defined. So you do not, you just need to inform the parties need to understand it because of the confidential principle that we always have in mediation. And that way it will make the mediation process not to stop. Then the mediation process allows advocates and other persons, as I said before, parties who want to be supported by third parties, they can come to have these people as support. This is unlike litigation, where you find that everything is informal. If you are not part of the process, then you cannot be invited to the table. Then with the court annexed mediation, you find that mediation agreement is possible, even in the most complex of cases. A good example is a case whereby parties had a matter in court for several months, but it was resolved on 10th of April 2017 within 49 days of being submitted, because we said we have 60 days. But this was a complex case. It was resolved very easily. And believe it or not, 42.6 million was unlocked and sent back to the economy. What does that tell you? Commercial matters is only that people don't say. Commercial matters, you find that they lock a lot of money, because if the dispute is not resolved, the other person is not able to pay, or is not able to get a way of paying by installments or other means that is able to achieve. Just in conclusion, I want to say that maybe many of us do not know, court annexed mediation is supported by the World Bank Judiciary Performance Improvement Project. It started as a project. so that we can improve the performance. There's no point of filing a case in court and then have that case stay there for years. Just say, every time you just say you have a case in court, it affects your mental status, it affects your economic status, it affects your social status. And so this court annexed mediation, it's fully supported by World Bank so that the judiciary can perform, can improve, and parties can resolve matters in a way that is peaceful. And we can have people who can be peacemakers. So you find in Kenya, based on the Constitution, Article 159.1, it is very clear that the courts are supposed to encourage alternative dispute resolution mechanisms. So for court annexed mediation to take place and to actually work, we need to continue talking. We need to continue talking about court annexed mediation, because people feel as if it's part of the judiciary, and yet they need to know it is just annexed to the court. The way it says, it is just annexed to the court, but it's still mediation, because the parties are the ones to resolve the disputes themselves with the help of a trained mediator within the 60 days, and they will be able to resolve the matters even where they're not talking. So it is time to encourage as many Kenyans as possible to understand that the court annexed mediation is not another litigation option. It's a way of resolving a dispute through the parties themselves. So court annexed mediation support system encourages all the stakeholders to share the mediation benefits for a peaceful society. I can tell you as a mediator, since I started in 2016, and being a lawyer for the last 20 years, I can say I'm being more peaceful as an advocate, as a professional, as a person, as a mother, as a wife, as a sister, as a neighbor, as a friend, through mediation when I started doing mediation in the year 2016. So you and I, we can create that peaceful ecosystem that will help the society that we are living in, where everybody is saying, tukutane kotini, let's meet in court. So in conclusion, as more and more Kenyans embrace and understand mediation, many disputes that are already in court or are being filed in court will be resolved through mediation. I want to thank you very much for listening, and God bless you.
Well, once again, I wish to thank you, Mediator Kipsang, for your discussion and for honoring us with the great opportunity to be able to learn more about the court annexed mediation. So today's discussion was a practitioner seminar series. We had Mediator Kipsang, who was taking us through the court, why use the court annexed mediation. Mediator Kipsang is a court annexed mediator. She's also the vice chairperson of the Mombasa branch of the Law Society of Kenya, and she is also part of Kipsang and Company Advocates, Mombasa, Kenya. So thank you very much, Mediator Kipsang, for this particular session. We will be closing now with the national anthem. Our next session is at 3:30 p.m., where we will have Mediator Maina Migwi, who is the director of Suluhu Mediation Center in Nakuru, and who will be taking us good practices in the provision of mediation services through online platforms. So at this juncture, ladies and gentlemen, we will have the national anthem, and then we can be able to close our session. So, Mungu nguvu yetu, ilete baraka kwetu, haki iwe ngao na mlinzi, na tukae na undugu, amani na uhuru, raha tupate na ustawi. So once again, I thank you all for joining us, and we will close the session now. Good evening.